5 seconds to go. Start. We threw his dead body into ditch and then left for our respective house. But Bogai Bouri has yet not paid us the money. I have nothing more to say. No doubt, the confessional statements have also implicated the maker substantially to the same extent as done against the appellant. The question, therefore, is to what extent the confession made by the co-accused persons can play in a criminal trial in the light of the provisions under Section 30 of the Evidence Act. Section 30 of the Evidence Act provides that when more persons than one are being tried jointly for the same offense and a confession made by one of such persons implicating himself and some other of such persons is proved, the court may take into consideration such confession as against such other person as well as against the person who makes all such confession. What is discernible from the provision of Section 30 is that it merely enables the court to take the confession into account, and how it is to be done have received consideration in various judicial decisions. A confession cannot be treated as evidence which is substantive evidence against a co-accused person. A constitution bench of the apex court in the case of Hari Charan Kurmi versus State of Bihar reported in AIR 1964 SC 1184 have held that in a criminal case where the prosecution relies upon the confession of one accused person against other accused person, the proper approach to be adopted is to first consider the other evidence against such a accused person, and if the said evidence appears to be satisfactory and the court is inclined to hold that the said evidence may sustain the charge framed against the said accused person, the court would turn to the confession to assure itself that the conclusion which it is inclined to draw from the other evidence is right. Therefore, confession can only be used to lend assurance to other evidence against a co-accused. The apex court held that in dealing with a case against an accused person, the court cannot start with the confession of co-accused person, but it must begin with other evidence adduced by the prosecution. In other words, the stage to consider the confessional statements arise only after the other evidence is considered and found to be satisfactory. It is well settled that the proper way to approach a case where conviction is based on confessional statements of other co-accused is first to marshal the evidence against the accused by excluding the confession altogether from consideration and see whether a conviction could safely be based on it. In the case in hand, the foremost point for decision would be whether the evidence other than the confessional statements of the co-accused persons on whose confession the trial court has primarily relied upon is satisfactory and sufficient to prove the prosecution case. There is no dispute to the fact that there is no evidence against the appellant either of having any inimical terms with the deceased or that the co-accused have been seen together with the appellant at any point of time earlier to the time of the incident or that there has been any recovery of weapons from the possession or house of the appellant. The manner in which the trial court proceeded for convicting the appellant has been by starting with the confession of the co-accused without first considering other evidence other than the confessional statements to derive satisfaction as regards the guilt of the appellant. There has been no marshalling of evidence against the appellant save and except the confessional statements of the co-accused persons. There is no satisfactory evidence other than the confessional statements of the co-accused persons to hold the charge proved against the appellant. At the most, the confessional statements may give rise to grave suspicion of the involvement of the appellant. However, such suspicion cannot take the place of legal proof. In criminal jurisprudence, there is no scope for applying the principle of moral conviction or grave suspicion. In the instant case, what is clearly discernible is that conviction of the appellant is based solely on the confessional statements of the co-accused persons by wholly disregarding the legal approach that is to be made while applying the provisions under section 30 of the Evidence Act 1872. In that view of the matter, and also in absence of any other substantive evidence against the appellant, the confessional statements of the co-accused cannot lend support to the conviction and sentence of the appellant. When the presumption of innocence is the basis of criminal jurisprudence, the fact and circumstances of the instant case cannot compel this court to hold that the charge against the appellant has been satisfactorily proved. Resultantly, the appellant is entitled to the benefit of doubt. As a necessary corollary, the order of conviction and sentence imposed upon the appellant is set aside and the appellant is ordered to be acquitted if not required to be detained in any other case. The impugned judgment dated 11th June 2015 passed in Sessions Case number 153 of 2010 insofar as the appellant Bogai Bouri is concerned is hereby set aside. Lower court records be sent back forthwith. Stop.